Hi, welcome to Constitutional Chats, hosted by me, Janine Turner,
and Kathy Gillespie,
with students
Dakari Chapman
and me, Tova Kaplan.
Join us as we discuss hot topic issues with constitutional experts. It's sponsored by Constituting America. I am Janine Turner, founder and co-president of Constituting America, and welcome to Constitutional Chats. Today, we are going to talk about the Supreme Court. There's a new commission that President Biden has appointed, and they're talking about many changes at the Supreme Court, the size of the Supreme Court, term limits, other things, which is why we're having the show today, so we can learn about them. So welcome to the show. Come on in. I'm going to introduce our fabulous panel that we have co-hosts on the show. First, we have we'd like to know if you're a middle school student or a high school student, college student. So Aubrey is going to put that up for us, and you can scroll up and down and just check who, the category that is yours. And we would appreciate that, because then we know who our audience is, and we won't use as many big words if we have an elementary school student. All righty, so Aubrey, I'm going to introduce Aubrey. Aubrey's simply fantastic. She's our director of media, and we're thrilled that she's with us today. She's a contest winner. Are we the future contest winner this year? And she's the middle of seven children? 7 children. That's in The Sound of Music. Is it? A captain with 7 children? What's the fearsome lot of that? Oh, there you go. Okay, so Aubrey, you want to say hello? She's in Utah, and she's attending Brigham Young University and aspires to be an athletic coach. So Aubrey, you can tell us about our panel,
Yes, definitely. It's funny that you mentioned The Sound of Music, Janine, because growing up, my maiden name is Vanderwerken, so everyone would call us the Von Trapp family.
Oh,
so it's kind of fun. So as far as the poll results go, first off, we have 5% elementary school students and 5% middle or high school students. And then the largest part of our audience is parents and grandparents with children, which is 30%. Then we have another 30% of fans, 15% friends, 10% family, and 5% donors. So we're so glad that all of you are here today.
We are. We're so glad you're here. This is going to be a fabulous show. Okay, I'm going to introduce the rest of the co-host. Kathy Gillespie, co-president of Constituting America. She and I are like the right wing and the left wing, no politics implied. And we fly, because without 2 wings, it's hard to fly and get off the ground. And you, the sponsors, and donors are the wind beneath our wings. And Kathy's going to talk about that today. Kathy, as I said, is co-president of Constituting America. She was a chief of staff on the Hill for decades. She's now one of the 17 private citizens that's been chosen to be a part of the Semi-Quincentennial Commission, planning this 250th celebration of our country. And I don't know what I left out. Oh, you were a big wig with the White House Fellows at some point. Kathy, you can talk about that. So Kathy, welcome to the show, and tell us about our sponsors today, please.
Well, thank you, Janine. I want to thank our sponsors for today, Bob and Doris Rice. They are just wonderful supporters of Constituting America for so many years. And Bob and Doris are also great supporters of the Constituting America auction that we do about twice a year to raise money for our Constitution education programs.
There you go. Yes, thank you, Mr. and Mrs. Doris. And now we're going to continue. I'm going to introduce Tova. My glasses are really weird. Tova Kaplan, we have known for 4 or 5 years. She's simply extraordinary. You're going to see her as, who knows, maybe even a Supreme Court justice someday, or the president at the UN representing America, ambassador to the UN, secretary of state, whatever she chooses to do. She speaks 3 languages. She's truly amazing. And Tova has won our contest 3 times, our We the Future contest, best PSA, best entrepreneurial marketing plan and best app, which we're still trying to get up. Someday we will get there. And she's also the CEO of our National Youth Board. She's National Youth Director of our National Youth Board. And she lives in Chicago, and she's a junior in high school, but you never know it. Tova Love Kaplan, please say hello.
Hi, everyone. Thank you so much for joining us. I'm calling in from my school. I finally got back in the building after a year of online, so this is super exciting. I'm so grateful to Janine and Kathy for having me on. They just work so hard, harder than anyone you know, to help keep this running. So please be generous and donate to the auctions that they can keep this going. I, as Janine mentioned, I'm a 3-time winner, and I've benefited so much from this program. I definitely would not have even 1/100th of the knowledge about the Constitution that I would without them. And, for the rest of my life, no matter what career I go into, I'll take the knowledge with me, and you can help make that impact with so many other students and adults. So please donate generously. They did not ask me to speak about that, but I just thought it would be good to say, please enjoy the show.
Thank you, Tova. You just are the light of our lives, and we think you're terrific. We can't wait we're going to say we knew you win. All right, now Julian Jorn and Gilbert, they're with us today, but Jorn is not. He's working the polls today. But Jewel is the executive producer, and Jorn is the operations director of Sing for America, a family-based company that the brothers co-founded. Sing for America seeks to show the art of truth and light through live performances. Both are proud former We the Future contest winners. Yes, they are. Sing for America is an actor-run theater company which specializes in semi-professional musicals, private training in the arts, school drama solutions, and public entertainment events, all while revealing a colorblind world on stage. Jewel and Jordan just recently graduated from Moravian College, where they each earned a BA in musical performance and dramatic production. And they just joined our show about, I guess maybe this is your 4th or 5th show. You bring such a level of intellect to our show, Jewel and Jordan. But Jewel, since you're the one with us today, you just are really terrific, and we're thrilled to have you. Hello, and gosh, we're going to see you clutching Academy Awards and Tonys someday. I just know.
We'll see that or something else. But today I'm actually at the polls too, but I'm able to take my lunch break out here in the nice picnic area, the church behind me, and do this show. So it's pretty cool.
How fun to be voting in the church. I vote in a very old, small, singular room country church from 200 years ago or something. It's really fun. It just makes me feel it's like America is a great place, which it is. Okay, our special guest. We are going to get to the program here. Everyone who's waiting. All right, here we go. Thomas Jipping of the Heritage Foundation. Thomas L. Jipping is Deputy Director of the Heritage Foundation at Heritage Foundation's Edwin Meese III Center for Legal and Judicial Studies, and a Senior Legal Fellow in the Center, which is a part of the Institute for Constitutional Government at Heritage. Woo, that's a mouthful. Tom has served on the staff of U.S. Senator Orrin Hatch as his chief counsel on the Senate Judiciary Committee at Concerned Women for America and the Free Congress Foundation. Tom has developed a national reputation among both liberals and conservatives as an expert in the federal judiciary, and in particular, the appointment of federal judges. Hence why he's with us today. Tom received a BA with honors from Calvin College, and my contacts are fogging up here, hang on, and both an MA in political science and a JD cum laude from the State University of New York at Buffalo. Tom lives in Fairfax, Virginia, quite different than Buffalo, isn't it? And it's a lot warmer, and is an active member of the New Hope Presbyterian Church. Hello, Thomas Jipping. We are thrilled you're with us today.
Hi, thanks for having me back.
Yeah. Well, all right. So now there's this commission that President Biden has orchestrated, talking about changes that maybe should and could happen at the Supreme Court. The hot topics, of course, are more Supreme Court justices or term limits you were talking about, numerous aspects. So we're going to let you open up and give us a little behind the scenes peek at the changes that may be happening, and then we will ask questions. And we'll
Sure.
the audience can ask questions as well. When we get to Kathy, she will be reading those for us. So welcome, and we can't wait to hear what you have to say.
Well, thank you. I think if you went to the doctor and the first thing you said was, I'd like a prescription for X, Y, or Z, probably the first thing the doctor would ask you, well, what's wrong? What's the problem? The diagnosis really is supposed to come before the prescription. And that's really where we're at with regard to the Supreme Court and ideas for supposedly reforming the Supreme Court. Lots of people are talking about those reform ideas, what they think they want to do, but nobody has really identified what the problem is, why there has to be any reform at all. And I think it is a very serious subject because, our system of government, and I know that you discuss various aspects of this in all of the different things that Constituting America does. Some basic principles like the separation of powers into three branches, as well as the independence of the judicial branch, those are very fundamental principles. So I think, even more than the general idea that you ought to say what the problem is before you start talking about solutions, I think we have to be very cautious and careful when it comes to suggesting significant changes, especially by the political branches, to the judicial branch. And that's what's under discussion today. Congress does have authority to change the number of judges on courts. They can even create new courts or move them around and that kind of thing. I mean, they do have authority to do that, but the way to distinguish between kind of meddling in the judicial branch and legitimately exercising Congress's authority, it's the difference between looking at what the courts need versus what the courts do. If the judicial branch needs more judges, if the Supreme Court needs more judges, for example, because it can't handle the workload or whatever, that's a legitimate reason to look at whether Congress should help. But if what you're looking at is, I just don't like what the Supreme Court does, and therefore let's add some more justices so that we can try to change the decisions of the court, well, that's what directly strikes, I think, at the heart of judicial independence. We've been through two of these rounds where this idea of so-called packing the Supreme Court, adding positions to the Supreme Court to try to change the decisions of the Supreme Court. We've been through two rounds of that, and it's been rejected both times. The first was in 1802, the 1800 election. John Adams, a Federalist, was the president. The Congress was in Federalist hands. The election of 1800 flipped the presidency to Thomas Jefferson, a Republican, and flipped Congress. But before they took office, the Federalist Congress quickly passed a law that reduced the Supreme Court from 6 to 5 so that Jefferson couldn't name anybody. Well, when the new Congress started, they repealed that law. And then some Republicans said, hey, let's go further. Let's not just restore that seat that was abolished. Let's actually add a couple of seats so that Thomas Jefferson can quickly fill those seats and send the Supreme Court in a different direction. And it was the Republican Party that said, no, we can't do that. That would be too much political manipulation of the Supreme Court. And of course, the second chapter was in 1937. That's the one that a lot of people will have heard about. Franklin Roosevelt wanted to do exactly the same thing. The Supreme Court had been striking down some of his legislation, his New Deal legislation that he wanted in order to take the country out of the Depression. And he suggested adding up to 6 justices to the Supreme Court. He could quickly fill them, and they would sort of overwhelm the justices that were already there. And then he would get the decisions that he wanted. Same reason, same strategy. And it was his political party, the Democrats, who overwhelmingly rejected that idea. They said, hey, everybody has their political goals. but we can't destroy the system itself by completely compromising the independence of the courts in order to achieve a few political goals. So we've been around this block a couple times with regard to court packing. That's the most common idea that's being discussed today, but there are others. People wanted to know last year what Joe Biden, what position he took as a candidate. He didn't really, he wasn't really clear about that. Instead, he said as president, he would appoint a commission to discuss ideas and issues related to the Supreme Court. But that was so vague that, again, it leaves you asking, well, what's the problem that they are trying to somehow solve? Unless they're really concrete about that, it just sort of plants in people's minds that there's something wrong with the Supreme Court, but no one really understands clearly why. So as it happens on March 19, which is the day after we're talking today, the Supreme Court Commission is holding its first public meeting. The executive order that President Biden signed says that the commission has to issue a report within 6 months of its first meeting. So I guess this starts the clock. And 6 months from now, the commission has 36 members, 32 of them are law professors. My experience is you can have 5 law professors in a room and they'll give you 12 opinions on any subject. So who knows what they're going to come up with. But that's really the question is there something wrong with the Supreme Court that has to somehow be fixed? The ideas that are being presented, do those go too far and really politically manipulate the courts rather than address its legitimate needs? So these are the issues that are swirling around today. Everybody has an opinion about the Supreme Court. They like or don't like decisions. But I think, especially if people listen to this program and listen to the other things that Constituting America does, they'll understand that there's a little bit more to it than simply, do I like what they're doing? So these are serious issues, and I'm glad we're talking about them.
Yes, thank you. That was most informative. I'm glad we're talking about it too. Okay. One of my questions is, what are some of the other things you think they'll be discussing? I think one of them are term limits. You can maybe touch on that in a second. But my first question is, we were at 5 in 1802, from what I gathered, or 6. They tried to make it 5, or 5. They tried to make it 6. I didn't quite catch that. When did it go from 5 or 6 to 9?
Well, when the Constitution created the Supreme Court, Congress created the other courts, but the Constitution created the Supreme Court, but didn't set the number. In 1789, Congress set that number at 6, 1 Chief Justice, 5 Associate Justices. That little back and forth in 1801, 1802 left it at 6. And by 1869, the Congress had set the number at 9, and it's been at 9 ever since. So for about 150 years, it's been at 9. One important thing, I'm glad you asked that question, because one important thing about the number of justices during the 19th century, we had a different judicial system in the 19th century. We had what were called circuit courts, which were trial courts, and they were in different regions or different areas of the country. And you had one Supreme Court justice assigned to each one of those circuits. They would actually go to those circuits and preside over trials. Very different than what happens today. They call that circuit riding. As you can imagine, as the country got larger, those trips became longer and longer and longer. But the number of justices was really, you needed it to have the number of justices equal the number of circuits, because the two were tied together. Well, Congress completely changed that system. The circuit riding and the circuit system was abolished in 1911. And so for over 100 years, there's been no connection between the number of justices and the number of circuits. The other thing, just to add to that point, is that since 1869, it's been at 9. As I said at the beginning, it's important to focus on maybe what the Supreme Court needs. Does the Supreme Court need more than 9? The only thing I'll say about that is that the Supreme Court today decides fewer than half the cases every year than they did just 30 years ago. Back in the 1980s, they were deciding 150, 170 cases a year. They decide about 80 cases a year now. It's hard to argue that when your cases are going down that you need more justices, but it's been at 9 for a good long time. Both Justice Ruth Bader Ginsburg and Justice Stephen Breyer, who were both appointed by President Bill Clinton, in the last year or so, were pretty forceful in saying 9 is the right number. There's no reason to change it. I do think that those who think we need more justices really would have to make the case that the court needs more than 9.
Okay, so my question is when, and then I want to toss it to everybody else. When this commission comes back and makes their recommendations, it's then up to Congress to vote and decide, not President Biden.
Well, it depends on what the particular reform idea is. One clarification, the paper that I'm writing, I'm looking at 8 different previous court reform commissions. Every single one of them did make specific recommendations. This commission will not, even though Biden said last fall that his commission was going to make recommendations that he would consider. The executive order that he signs does not assign them or direct them to make recommendations. That's one of the problems with this commission. They're going to talk about sort of arguments and issues and this kind of stuff, but they're not going to come to any conclusions. They're not going to actually make any recommendations. It is true, though, that if the issue is the number of justices, well, Congress can do that by legislation. If the issue is term limits, you'd have to amend the Constitution to do that. And then depending on what other ideas might be on the table, how to accomplish them would depend on what they are. But I think that's a very important thing to understand. This commission's very different than commissions on the courts or any other topic, because it does not look like they will actually make recommendations.
Well, what's the difference between an idea, if they're going to give President Biden ideas, and a recommendation? What's the point? Why?
Well,
Why?
the question
For no
that
recommendation.
is the question. What's the point of the commission if they're not going to actually suggest anything? I haven't seen any commission appointed by Congress, the president, or anything, and I've looked back for 50 years, where there's this, it's important to bring this body of experts together, but all they're going to do is sort of chat. They're only going to talk about stuff. They're not going to actually look at a concrete problem and make a particular recommendation. If they're not going to do that, what's the point of having these people come together and talk? I mean, we're doing that here on this program. The point of these commissions is typical. In fact, it's consistently that these are experts, and there's a serious problem or issue that needs to be addressed, and we need their help in sort of directing and focusing what's being done. And they do that by making recommendations. Every single other court reform commission has done that. This one won't. I think that's partly because what they're really trying to accomplish is just kind of stir up in people's minds the idea that there's something wrong with the Supreme Court, but they really aren't going to give us any guidance about what it is.
That's just, okay. Well, that's unfortunate. And so this is a lightning round question. So maybe in 2 words, what are you saying that all other commissions that you've known about, whether it's about the judicial system or not, always give recommendations? Is that what?
Yes, there's 2 kinds of commissions. One investigates. The Warren Commission, for example, investigated John F. Kennedy's assassination. They make findings of fact, but every other, the most common kind of commissions, which are study commissions or analysis type commissions, they all make recommendations, and this one won't.
Okay, so this is an anomaly.
It is very much.
So that everyone understands too, circuit, just to make that clear, because the circuit court was really kind of cool. They got on horseback.
Yes, in the 19th century, this is why it quickly became a problem that needed to be changed, because obviously everyone knows Washington, D.C. is on the far end of a very large country. And as the country quickly added more states, and it grew very quickly going to the west, depending what circuit you were assigned to, I mean, you might have to make a trip to the middle of the country by horseback once or twice a year,
And so
which really takes its toll.
The Supreme Court justices were getting on horseback and going around the country, and that's why they needed more, because the country was expanding. So there was really a need at that point. Okay, Tova, you're on.
Thank you. This is really fascinating. Could you talk about the Supreme Court, how it was, originally conceived of by the founding fathers? So why did they structure it the way they did? Why did they make Congress able to add or remove seats, but not let them impose term limits, for example? So could you just talk about the original conception?
Well, the most important concept in the organization of our government is the separation of powers and checks and balances. Those two kind of go together. The separation of powers means that the judicial branch gets judicial power. It doesn't get other kinds of power, but it's not left, completely by itself in exercising judicial power. There's some limits that are added to that. One of those protects the Supreme Court and the federal judges from retaliation by the Congress. That's why they can serve unlimited terms. And because that's in the Constitution, the only way to change it is to amend the Constitution. One of the reasons that we declared independence from Great Britain was to protect the independence of the judiciary. The Declaration specifically mentions that judges in England could be fired by the king anytime he wanted. That's why their unlimited terms are protected by the Constitution. So they do have judicial power, but they're protected again from retaliation by the Congress. On the other hand, the Constitution gives the legislative branch power to create other courts. You see, so it's a balance. It's and then that's, I think, one of the ways that our system is really well designed, and why, if we're going to somehow upset that balance, we really ought to have a good and compelling reason to do it.
Thank you. And then if let's say it does become a possibility that seats are added to the Supreme Court, how do you think that would change the institution, and how do you think that would, if at all, impact the decisions that individual judges might make or that the court might put out?
Two ideas on that. One is some people think, in the way the debate about court packing today goes, some people get the impression that it's really easy to predict what individual justices are going to do, how they're going to rule on particular cases, what cases are going to come before the Supreme Court 10, 15, 20 years from now. And that just isn't true. President Dwight D. Eisenhower, who was a Republican, is said to have, when he was asked, do you have any regrets about when you were president? He supposedly said, well, two of my biggest mistakes around the Supreme Court, those being Chief Justice Earl Warren and Justice William Brennan, who turned out to be very political, activist judges, something Eisenhower didn't expect at all. Take the abortion decision, Roe versus Wade. It was written by a Republican appointee, Chief Justice Berger, Justice Powell. Those are Republican appointees. They were in the majority. So it's not nearly as easy to predict and to kind of program the Supreme Court as some people who are advocating court packing today would like to think. But in addition to that, it would set a terrible precedent. As I described, we've come up to this, edge of the cliff twice before in our history. And both times, one Republican, one Democrat, they said, we can't, once you let that genie out of the bottle, once you've decided, okay, it's all right to explicitly politicize the Supreme Court, manipulate the Supreme Court in order to get decisions that you want. Once you've decided that's okay, judicial independence is gone and you will not get it back. So it's hard to make it work. And also, even if you could, it would be a really destructive idea for what's so important about our system of government.
Wow, thank you for elaborating on that. And then just one more small question. You mentioned earlier that the number of cases that the Supreme Court is ruling on have decreased sharply. So why is that?
Well, the Supreme Court is different than lower courts. I was a law clerk for a judge on the U.S. Court of Appeals, for example, and that's in the Third Circuit, which is Pennsylvania, New Jersey, and Delaware, where all the cases that come into the Third Circuit are divided up among the judges that are on the Third Circuit. So each judge gets some of the cases. Well, on the Supreme Court, every justice decides every case. And so, it won't help to handle the caseload if you add more justices, because every justice handles every case. So the way they've tried to help is to try to limit the number of cases that come into the Supreme Court. They've given the Supreme Court much more control over the cases that it considers. You don't necessarily have a right to automatically have the Supreme Court hear your case. And that's helped quite a bit. And I think the court has become more careful in selecting a smaller category of cases that it should get involved in. The Supreme Court is not simply another appeals court, kind of a second bite at the apple if you lose, in the Court of Appeals. It really is supposed to settle disputes between lower courts that decides the same issue differently and referee those kinds of legal conflicts. And so I think it's a good thing that they're more careful in how they select their cases. But I think that's what's helped diminish that total caseload.
Okay, thank you, Tova. Jewel.
So the court packing in general just seems like it's just hard for me to even see the other side, and I wonder what could be the best possible reason to say functionally we should add seats.
I think there's two answers to that. One is if the argument can be made that they need more seats. When Franklin Roosevelt proposed doing this in 1937, he tried to argue that the number of cases coming before the court was going up and up and up. They needed more justices to handle the workload. I just explained why that really doesn't make sense. But that would be one reason, is kind of from an administrative perspective, that somehow they need more justices. The real reason that Roosevelt wanted to add justices in 1937, the reason that people are suggesting doing so today, is that they want to change the decisions of the court. They don't like some of the decisions in this area or that area. And so they want to, the Senate Judiciary Committee, when they issued their report on Roosevelt's bill in 1937, the way they described it was they want to kind of overwhelm the justices who are there by this bunch of new, members that will change the votes of the court and make the court decide cases differently. The issues in 1937 had to do with the New Deal, economic regulation. Today, they tend to be more kind of social issues, abortion, gay rights, gun rights. And so if you look at the groups that are pushing court packing today, what they say is, we need to expand the court in order to achieve certain results. And those results are kind of consistent with their political agenda. So, if an argument could be made that they needed more justices, I don't know what that argument would be. That would be one way of doing it. But I think the real reason is because people just don't like what the court's been doing, and they want to get different decisions out of the court. So they're going to try to change the court in this way.
Why does it seem like our political adversaries, like the other side, who would see court packing as good, seems like their philosophy is centered around means to an end. So whatever means to get to their political end would be okay, whereas we may want to see different decisions. I think that most of us here think that some of the Supreme Court decisions are what made our whole country fall apart. Certain particular decisions we could point to, but we wouldn't say, okay, well, let's add some more seats. So what do you think that difference is? Why do you think that they would be so short-sighted to think that it's worth it for right now, even though knowing that, well, then what happens in 4 years?
I think you've put your finger on exactly what the core debate about the judiciary is. There's judges come in kind of two different varieties. One is one of them thinks that the ends justify the means. It's the result, the goal, and whatever you have to do to achieve that goal is legitimate. The other kind of judge looks at the process of applying the law to whatever the result the law requires. So one is a very process-oriented perspective, and the other is a very result-oriented perspective. I think the founders of our country designed our judiciary with a process perspective in mind. Judges are supposed to take the law as it is, apply that law impartially to decide legal disputes. They're not supposed to pick winners and losers ahead of time and then try to manipulate the law to get there. That's been the debate about how much power judges should have since our country was founded. And those who advocate court packing, whether it was Roosevelt in 1937 or some more liberal groups today, they have that very result-oriented kind of political perspective on the courts. They see the courts as really no different than Congress, and what they want is the result. They want a result that is politically correct, perhaps, rather than judicially correct. And so that is what the debate is about. The arguments against court packing and for judicial independence are arguments about the way the judiciary was designed to work. And I think that's what we ought to hold on to. But that ends justify the means idea is exactly what the debate about the judiciary has always been about.
And it's hard to have the discussion when that's the real argument. But we're talking about the effect of a different belief system, basically.
It can be, except I actually think if we had more of the debate about that issue, which of those two kind of models is the right way to look at the judiciary? I mean, I worked in the United States Senate on the Judiciary Committee for 15 years and worked for Senator Orrin Hatch on several different Supreme Court nominations and participated in, hundreds of debates about judicial appointments, and very, very few of them were about that issue. And yet that is the issue. It's not what organization this judge belonged to when he was a freshman in college or something. And it's certainly not about trying to get a nominee to promise to rule a certain way on a certain issue. It's about what kind of judge are you going to be? Are you going to follow the law, or are you going to try to drag the law where you want it to be? And I think if the debate could be about that issue, because that's what the founders of our country debated, that's the decisions that they had to make about how to design the judiciary, I think we'd all be better off for it, frankly. Those are challenging issues, but it is the real issue. Instead, we get this misleading stuff about, are you pro-gun or are you anti this or that, and I don't think it helps the American people really understand the judiciary.
I agree 1,000%, because we are always talking about things that are far downstream than the real debate. And the real debate is in what works, what's true. I have a harder question I want to try to formulate, because thinking about something like the 2020 election, and not particularly about what happened there, but if we could believe that the Supreme Court allowed an election to be unfair as in a state presented a case against another state, or within a state, they presented a case within a state where a constitution was violated, would that raise to the level of where you would say, well, we would need to pack the court in order to ensure fair elections? If we
No,
had the House, of course, in that situation.
it is never the right reason to change the number of justices on any court that you're trying to produce different decisions. That is never the right reason to change the number of judges on a court. I think, unfortunately, people understand so little about how the courts are supposed to handle an issue rather than, let's say, the political branches, that when it comes to a scenario like you were referring to, it's almost impossible for most people to think about it any other way than, the court didn't do what I wanted them to do, as opposed to, when that case came, I think the one that you're probably referring to, when that came to the Supreme Court, Texas was suing 4 other states to invalidate the result of the presidential election in those states because of what Texas said had gone on politically in those states. That may have been a persuasive argument in a town hall meeting, that may have been a persuasive argument in a law school classroom, but the Supreme Court had to decide, well, does one state have the authority to challenge how another state counts its votes in a presidential election? If the answer is no, it doesn't matter what arguments they're making. They don't have authority to raise that issue in court. And that's what decided the outcome of that particular case. Unless people understand those differences, all they're going to say is, I wanted Texas to win. Texas didn't win. Therefore, the court was wrong. It's like you're kind of holding up your finger to the wind and seeing which way the wind blows. That may be how you decide who to vote for the Senate. It's certainly not the way we should evaluate what courts do. But, people have to understand more about the way our system is designed to work. 10% of college graduates think Judge Judy is currently serving on the Supreme Court. It's in that situation, it's going to be pretty hard in the middle of a very hotly contested presidential nomination or season to make some of these distinctions. And the media, of course, they don't help at all.
So we probably need to move to Kathy now for the last section here. And what I keep thinking about as I toss to Kathy is just the decisions are supposed to be made what's constitutional, not social issues, not because the social issue of today could swing and be a completely different social issue in a decade. It's not supposed to be to vacillate on social issues. It's supposed to be, is this constitutional or not? And then I started to think, well, that happened after Marbury versus Madison, which that switch about having to say if things are constitutional. But what was their initial before Marbury versus Madison? But they didn't necessarily develop it to be constitutional, to be based on the Constitution originally, correct? And may please answer very, 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 very quickly, because I want to get to Kathy.
I don't think Marbury versus Madison invented the idea that the Supreme Court could decide whether laws are constitutional. I think the founding fathers designed that into our system. Somebody had to decide when there's a conflict between a law and the Constitution, and that should naturally be the court. So I think that was in their design from the beginning.
Okay. All right, Kathy, go ahead.
Well, thank you so much, Tom. One of the biggest takeaways I've had from what you said today is that any changes to the judiciary should be focused on the judiciary's needs and not their actions. I think that's just so insightful. We've got some great audience questions, and if we could get to some of those. First of all, Jerry Kohler asks, does increasing the number of Supreme Court justices require just a simple majority vote?
It requires legislation, which would be passage by the House or Senate. Because the Senate is 50-50, however, and because Senate rules allow for the filibuster, Unless you change that Senate rule and get rid of the filibuster, it would take 60 votes in the Senate for a bill like that to pass. So simple majority in the House, 60 votes in the Senate. That's why some people say we ought to also abolish the filibuster to get their way.
Mm. And then Chase Price asks, what is your opinion on the Keep 9 amendment now endorsed by more than 180 members in the U.S. House and Senate, along with the unanimous endorsement by the RNC? Are you familiar with that?
I am. That would basically set the number of justices on the Supreme Court at 9 in the Constitution. I think as a way of saying that we shouldn't mess with the number on the Supreme Court. It's motivated correctly. I think a couple of the questions that need to be asked is whether what has been a legislative issue in the past would now be turned into a constitutional issue. And I think that's worth asking whether that's the right way to go, as well as whether there's really anything magic about the number 9. It hasn't always been 9. It has for a long time, but not always. It's conceivable that the number might be rethought in the future, but if you constitutionalize it, then it's locked in stone. But I think as a way of saying, messing with the size of the Supreme Court for the purpose of redirecting the Supreme Court's decision has to be fought on all fronts.
Has to be fought what?
I'm sorry?
What did you say has to be fought what?
Has to be fought on all fronts.
All fronts.
Every way that we can, we have to resist that effort to manipulate the Supreme Court.
Got it.
Robert McKeeman writes, how about having an even number of judges on the court, which means that a majority would require at least a 6-4 vote, which would mean that a majority would not be decided by just one justice?
Well, that argument could be made about any legislative body anywhere in the world. There's no, a majority of the Congress is the action of the Congress. The majority of a town council is the action of the town council. If you want to have a super majority, I think there ought to be a specific reason for one. But again, there's nothing wrong with the number 9. There's no, the reason to change that number is because the court needs it to be changed, not because you want to have different outcomes or you want to somehow make the court make its decisions differently or something along that line. I think that goes too far in kind of meddling with how the court exercises the judicial power that the Constitution assigns to them.
Well,
Now, what if you?
Oh, hey, Jordan, I'll come to you too. But what's interesting about that is just because there's a one swing judge today doesn't mean in 2 decades that it would line up the same way. You might have 7 Democrats and 2 Republicans, so you wouldn't need 10. I mean, it's not always going to be that sort of political alignment that it is now.
It's also, if you look at actually if you look at the court's actual decisions and you look at the issues in those decisions, you will often see it's easy to say, well, it was a 7-2 decision. Well, many times there might be 5 different aspects to a case resulting in 5 different groups of 7 justices. The majority shifts from one issue to the next, and the actual real way that the Supreme Court decides cases does not always lend itself to nice, simple equations. And that's why, it's functioned perfectly fine for an awful long time.
Jordan, Jewel, very quickly, because I want to get back to Kathy.
Yeah. Just thinking about the gentleman's question. What if the case was though that you're thinking that it's a better way to enact the philosophy that created the court in the first place, that it would depoliticize it somewhat, and your point is that it's functioning in a way that is different from the way it was designed to function. So yeah, the outcomes of cases would be part of your determining factor, but your point wouldn't be you want a different outcome. Your point would be that you want a more true process.
Well, the way that the founders decided that judges do 2 things. They interpret the law and they apply that to the facts to settle a legal dispute. that the founders designed the courts to approach both of those tasks impartially. And the size of a particular court or the number of judges doing that was never part of their discussions. They always focused on how a judge should decide every case. What approach should a judge take to all of their cases? And that's what really we ought to be focusing on when it comes to which judges should be on our courts.
Okay, Kathy, go ahead.
Charles Downs is active with the Keep Nine movement, and he just wanted to invite anyone who wanted to know more about that particular way of keeping the number of seats at 9, just to go to keep9.org. So I wanted to be sure and read Charles's comment that he sent. And then Jay Epperson asks, on the SCOTUS decisions, are SCOTUS decisions actually law, or are they only opinions?
Well, I think there's two aspects to that. The word law can be a little bit confusing, but with regard to the case that is before the Supreme Court, the decision of the court settling that legal dispute between those parties, that could be considered law. The decisions of the court interpreting and applying the Constitution or statutes become precedents of the court, so that the court in future cases, when they decide the next legal dispute, can rely on those. I don't think that they're necessarily law in that broader sense. The Constitution and the Supreme Court's interpretations of the Constitution are not the same thing. In fact, even liberal justices have said, you know, the Constitution and what the court has said about the Constitution are different. But I think with regard to the individual case that's brought to the court, the parties bring their dispute to the court decides it. I think that's a legally binding decision with regard to them.
You know, that's a really fascinating question, actually, you know, and there have been some presidents who have just ignored Supreme Court decisions, because I would imagine once the Supreme Court gives their opinion and it has to become law, it has to go back to the executive branch to be executed to become law. I would think that'd be correct. And a lot of times, is it Andrew Jackson that just said no? I mean, it wasn't Andrew Jackson. I don't remember this, but he just said
it
no.
Was. In the Federalist Papers, when Alexander Hamilton wrote Federalist 78 and explained the judiciary, he said the courts exercise judgment. They don't have the power of the purse like the Congress does. They don't have the power of the sword like the executive does. They just exercise judgment. So it's the persuasiveness of what they do and how they do it that really is the foundation for people's respecting what that branch of government does. To me, that counsels against courts getting too political, playing fast and loose with what the Constitution means, delving into all sorts of, social controversies and this kind of thing, because that puts the Supreme Court's judgment in a lot of doubt, and frankly weakens the basis on which people respect the judiciary. So there is that big difference between the judiciary and the other branches. And frankly, I think when the founders said the courts were the weakest and least dangerous branch, they were counting on the courts knowing their place and staying in it.
Yeah, well, that hasn't happened. Kathy, we have about 3 minutes.
We do have one last question, and then we'll have made it through all our audience questions today. Jerry Kohler asks, how many votes are required to confirm a new Supreme Court justice? He's wondering if it was changed, did the Democrats change the vote requirement to a simple majority? I guess we'd still be still have the filibuster to keep it to 60, or how does that work?
Well, as I said, with legislation, Senate rules require 60 votes to end debate before the Senate can actually vote up or down on a bill. That same rule used to apply to nominations. And in 2013, Democrats eliminated that rule so that it was just a simple majority to end debate on all but the Supreme Court. And then in 2017, Republicans extended that to the Supreme Court. So now today, Ending debate is a simple majority, just like confirmation is a simple majority. So there is no filibuster for nominations anymore. There still is for legislation.
Okay.
So it is just a simple majority, but it's only the Senate that's involved. You know, legislation obviously involves both houses. The House is not involved in the judicial appointment process.
Could you explain to our audience in the last 120 seconds here what a filibuster is? Because that's thrown around a lot and so many Americans don't even know what
Sure.
that is.
I think it's better called extended debate. The way the Senate is designed, it's different than the House. The House does everything by simple majority. Even if it's very, very close the way it is today, if the majority sticks together, they get whatever they want. In the Senate, it takes a supermajority to end debate. And that allows smaller groups of senators to have more influence. That's extended debate. A filibuster happens when you can't stop extended debate. You hold a vote, you can't get to 60, that's a filibuster. And so, you know, the majority doesn't like it, the minority always likes it. But I think it adds something significant to the way the Senate does its business that's different than the House, but it complements it too.
Isn't the filibuster when they get up there and talk forever so that the process can be impeded, like Jimmy Stewart?
The talking filibuster is a myth. A talking filibuster like Jimmy Stewart did in Mr. Smith Goes to Washington, that's just a long speech.
I saw that they've done it. Ted Cruz did it and read all the books to his children.
Those were just long speeches. A filibuster
it wasn't part of the filibuster?
No. The filibuster that actually keeps legislation from being passed is a vote. When it takes 60 votes to end debate, and when you don't get to 60, it doesn't matter whether senators have been talking or not, you hold a vote, and if you can't get to 60, that's a filibuster. Those other things are just long speeches. When Ted Cruz did it, that was arranged ahead of time, had no effect on the vote that occurred thereafter. I think that, you know, I'm glad you asked that, because that's a little bit of confusion. A filibuster is not about theatrics, it's about procedure. And so when you can't get to 60 votes to end debate, that's a filibuster.
When you can't get to 60 votes ends the debate.
It takes 60 votes to end debate.
But if it can only get to 58 or 59 votes, the filibuster comes in and says, we're just stopping. That's all the filibuster does.
If you have 58 votes, debate does not end, and you have a filibuster. That's the definition of a filibuster. The word debate can be a little bit confusing. That doesn't mean that there's actually senators down on the Senate floor talking morning till night. Even if no senator gives any speech on it whatsoever, Rule 22 of the Senate requires that you take a vote if you're going to bring that phase of the legislative process to a close so that the Senate can vote up or down. That vote requires 60. The word filibuster, I mean, the word filibuster is not in Senate rules or anything like that. It just sort of sprung up. But if you're going to use the word filibuster, it means you can't end debate. And you find out that you can't end debate when you take a vote to end debate. And you can't get to 60. So
they do continue debating. That's the point, to continue debating.
Well, again, the word debate does not mean that senators are down on the Senate floor talking all the time.
But it can mean that. It means that the debate hasn't ended. They're going to continue talking, and we got to stop. We're late.
It can, but it doesn't require that they've been talking at all. Senators can give a speech for as long as they want, any time they want. Yeah. It doesn't have to have any connection to a bill whatsoever. A filibuster is a procedural obstacle that, in order to get to a final vote, the Senate has to end debate. In the House, you can do that by simple majority. In the Senate, it takes 60 votes. And if you can't get to 60 votes, it's a filibuster.
They can't get to 60 votes because they don't want the vote to take place, the actual piece of legislation to happen.
There's different reasons for it, but that's the sort of tactical purpose of it. They don't have the votes to defeat a bill, but if they can get 41, 42 senators to vote against ending debate, they can get their way anyway.
Okay. All right. Thank you. It was really awesome. Thank you, everybody. everybody. Thank you, Thomas Jipping. You were really terrific. Really, really great.
Thank you for having me.
Yeah, thank you so much. Thank you, Aubrey. Thank you, Jewel. Thank you, Kathy. Thank you, Tova. And thank you for joining us. And Kathy, you want to quickly tell them about next week?
Yes, next week we're going to be talking about COVID vaccine cards and the Constitution. Can the government require you to have a vaccine card for COVID? And then the week after that, we're going to do Ellis Island Part 2. So we invite y'all to check our website and go on and sign up and come back next week, Tuesday at 2 p.m. Eastern.
Okay. Thank you, everybody. Have a great day. Thank you, Mr. Jipping.
Thanks. Those are great issues.